And a half or so on the negative. And just thinking about this topic, you might think that it's incredibly challenging on the negative, and it is in some ways, especially if you are planning to use very traditional case attack kind of arguments. But we'll talk about those as we go along. Again, a reminder, the national topic this year, which by the way, was originated with Colton Gilbert, who's the debate coach at Little Rock and home of Brown v. Board of Education. If any of you had the opportunity to visit Little Rock and to see that site, it's pretty interesting that this topic was authored by an African-American brilliant young man, Colton Gilbert. So the wording of the topic: the United States federal government should enact substantial criminal justice reform in the United States in one or more of the following: forensic science, policing, sentencing. So if you've attended my sessions before, you've seen something like this slide, the negative toolbox with topicality, disadvantages, case arguments, counterplans, and critiques. I will refer somewhat obliquely on occasion to counterplans and somewhat less to critiques. Let me just stop for a minute and say about critiques. Critiques are not my favorite when they have nothing to do with the topic. When critique-like arguments have a great deal to do with the topic, as race-related arguments will this year, that's a totally different story. So it's not the subject, though, of our discussion today. We're going to talk mainly about topicality and case side and disadvantage arguments. Again, I'll refer a little bit to counterplans, and there is a PowerPoint that you can download. It's kind of a short introduction to counterplans. It's pretty simple for those of you who are experienced debate coaches. I'm sure you've already thought well beyond the suggestions that I have in that counterplans PowerPoint, but it could provide a way for you to give your debaters who haven't been introduced to counterplan theory a kind of a quick little look at some likely counterplans on this topic and the kinds of arguments that relate to the non-topicality and competitiveness of the counterplan, as well as permutation arguments. But let's begin with topicality, which is a very considerable weapon on this topic if you're negative. And that starts with the choice of the word enact in the resolution. Now, I do have to tell you that in the topic paragraph that Colton wrote and the members of the topic selection committee, they included these couple of sentences. Affirmatives can explore different ways to improve policing. These could include, but is not limited to, body cameras, increased community policing, instituting community review boards to investigate police misconduct, or can overturn Supreme Court decisions that have increased protections for police officers. So obviously, when Colton prepared the topic paper, he envisioned that affirmative debaters could be talking about overturning Supreme Court decisions, and I'm confident that there will be a fair number of those affirmative cases this year. However, the use of the word enact in the resolution is problematic for those kinds of affirmative approaches. Enact typically refers to the passage of congressional legislation as signed by the president, not action by a court. Consider the fairly official website of the U.S. court system, Administrative Office of the U.S. Courts, and their little introduction to the federal courts that's entitled Understanding the Federal Courts, the citation that I've given you there, says this: the courts do not enact the laws. That is the responsibility of Congress, nor do the courts have the power to enforce the laws. That is the role of the president and the many executive branch departments and agencies. Brian Garner, in Garner's Dictionary of Legal Usage, he's also, professor of law at UC Berkeley, but also the current editor of Black's Law, defines enact this way, he says about enact in in this case, Garner's Dictionary of Legal Usage. The platitude is that courts adjudicate rather than legislate. Some judicial decisions seem to belie this principle. Still, it is unidiomatic to refer to a court as enacting doctrines. Webster's defines enact as to make a bill into law, to pass a law. Collins English Dictionary defines enact as to establish by law, ordain, or decree. So if you download the topicality document that I've made available and that Jana has made available for you to download, you will discover a couple of definitions that affirmative teams can use when they want to argue for the topicality of courts as enacting a rule. But I do have to tell you that the weight of definitions of this word enact seem to argue against court decision making. So that's a pretty powerful negative beginning for any case like a capital punishment, overturning Supreme Court decision, or some of the others that we talked about on the affirmative side, where the affirmative plan would have the Supreme Court rule in a certain way. So certainly something to consider. Sentencing doesn't mean legalization. The typical definitions of sentencing clarify that it refers only to the post-conviction phases of a criminal trial. So the resolution in that sense gives no power to change what is legal or illegal, but only the penalty for illegality. And that's a pretty important limitation if you stop and think about it. Very often when we sit down as a wording committee, thinking as part of the topic selection committee process, thinking about finding a resolution that has some reasonable limits to it. What would you think about a resolution that would actually allow an affirmative team to make legal anything that is now illegal, or to make illegal anything that is now legal? That kind of a resolution would have absolutely no limit to it, because this topic talks about enforcement of laws, and if you could change any law whatsoever, you'd be debating every topic that we've ever debated. You'd be debating anything environmental, you'd be debating anything with education, you would be debating really anything where a part of the legislation would involve a criminal penalty. So a negative team will argue that a reasonable limitation to this topic, which still, by the way, allows a great deal, is a limit that would say sentencing only can refer to the penalties that are to be served for violating existing law, not for changing the law, either by making something new illegal, or by making something legal that it's now illegal. As you see on the screen, Mark Davis, Concise Dictionary of Crime and Justice, says sentencing, the phase of the court process at which the defendant is punished. In many felony cases, the presiding judge uses a pre-sentence investigation report for assistance in arriving at a more just sentence. Sentencing options include prison or jail terms, probation, fines, or other alternatives. So really, the affirmative team, when they're talking about the sentencing part of the resolution, can't be talking about legalizing something. They need to be talking about changing the sentencing for something. So for example, you could use community direct corrections in place of prison. I guess you could theoretically even sentence a person to nothing, but keep in mind, those kinds of affirmative cases will make themselves very susceptible to a legalization counterplan. And when we talk about disadvantages, it shouldn't be very hard to find ways that that counterplan would be net beneficial. So that's a very important limitation, and negative teams need to get used to holding the affirmative to that limit, because, you know, that way you don't have to debate drug legalization. And the ground that you're preserving is you can debate legalization versus decriminalization. And there's a big literature on that, arguing that if you're going to get rid of penalties for drugs, rather than giving a person a criminal record, regardless of what you're sentencing them to, you should legalize rather than just decriminalize. Decriminalization is favorable in the current environment just because people think that that's easier to achieve politically than would full legalization. But if you're debating in a fiat world where you don't have to worry about political adoption, why wouldn't legalization be a superior alternative if you're just getting rid of penalties? When the case deals with policing and the definition of policing, negative team needs to argue again that that does not allow legalization. Again, that would unlimit the topic. If you could say that you're changing the job of police by making something illegal that's now legal, or vice versa, then again, you're debating every topic. You know, police have the job of enforcing the law. So this topic limits the discussion to the way that the police are carrying out existing law rather than to change the law that they're enforcing. This definition from the Longman Dictionary of Contemporary English: policing, the people who work for an official organization whose job it is to catch criminals and make sure that people obey the law. So we're talking about, and again, that leaves so much for the affirmative. So much of the current debate that we're engaged in politically involves not what the laws are that police are enforcing, but instead the methods that they use in enforcing the law, with protectual stops and that type of thing. So, and the use of unnecessary force. So that's a reasonable limit to put on the affirmative. Well, what can you say about substantial? If there are any of you here who are fairly new to debate, just be aware of the fact that for whatever reason, we use substantial in every debate resolution. It's been there for more than 3 decades in every resolution but one. And so there are lots of definitions of substantial. It's a word very commonly used by legislatures and by Congress. And there are just a mind-numbing number of definitions of substantial. So you'll have affirmative cases that seem to deal with a fairly minor amount of people in prison, for example. Let's say decriminalization of marijuana. And then when you have a negative team read evidence that, well, less than 1% of people who are in prison are there because of marijuana offenses, they would argue that 1% is not substantial. But also you can look for field context evidence about what's substantial in the context of criminal justice. Here's a very interesting piece of evidence that I found. And by the way, train your debaters that when they're doing their research, their eyes should just light up whenever they see any of the words in the topic, like enact or substantial or sentencing or policing, because that's contextual topicality evidence. And so this particular piece of evidence in the Wake Forest Journal of Law and Policy, in recent years, there's been a growing consensus among ideological lines to address mass incarceration, yet policy changes are incremental in approach and do not achieve the substantial reforms needed to significantly reduce the rate of incarceration and its collateral impacts. And then she actually lists what she thinks are incremental versus substantial policy reforms. So reducing the quantity differential between crack and powder cocaine, reclassifying certain felony offenses to misdemeanors, expanding voting rights and access to public benefits for persons with felony convictions, adopting fair chance hiring policies. She argues all of those just nibble at the fringes of the problem. Those are incremental, not substantial, according to the context of her evidence. So look for that kind of evidence that you can offer in a debate as from a field context expert talking about what a substantial reform would look like. Then we have that phrase in the topic, criminal justice reform. Typically, what's on the other side of criminal justice is civil law. So you have criminal law and you have civil law. This applies in a very significant way for immigration cases because most of what happens in immigration law is a matter of civil rather than criminal law. And this particular piece of evidence from Lash, Yale Law Journal Forum, the Supreme Court has explained that immigration arrests that initiate deportation proceedings are civil in nature. So you'll find a lot of evidence both ways on whether various things the Trump administration is doing with immigration relate to criminal law versus civil law. But pay attention to that because it has topicality implications. Then there's the word reform. This provides a major opportunity to the negative if you want to use an abolition or defund the police counterplan or even a movement's disadvantage based on those things. If you just Google up, criminal justice reform, and then just add the word abolition, you will find a great deal of discussion of whether reform is consistent with abolition or whether it diffuses abolition, whether in fact it diffuses the grassroots movement. And all of that evidence is going to be relevant in counterplan arguments, but also here in topicality arguments, because you will have some affirmative teams that will try to obviate a negative topicality or a negative counterplan argument, a counterplan based on abolition or defunding police, by actually doing it on the affirmative. And so you need to have enough evidence when you're negative to establish that reform is not abolition. That if you reform something, you're working within the system, you're not abolishing the system. So here's an example that I just Googled up. We do still need police, the argument goes, but policing as we know it is so broken that departments can't simply be reformed. It will take scrapping our current police forces to allow a new and better version to emerge. So, if you want to use a movement's disadvantage or a defund the police counterplan versus an affirmative case that is trying to do defunding or abolition, you need to argue that's negative ground. That's not affirmative ground. Then a pretty obvious one, federal government doesn't mean the states. It means the central government in Washington, D.C. And that's major on this topic because we've talked about it with so many affirmative cases. Really, the affirmative team is having the federal government clean up state and local policing problems. Almost all of the stop and frisk, all of the issues that have arisen with excessive use of force, I shouldn't say all, but predominantly all, have been at the local level. And so the affirmative team needs to, when they have an affirmative plan which tells states what to do, that's problematic because the resolution says the federal government should enact. So the affirmative team at least needs to be limited to something that's going to create a funding incentive for states. You can't just mandate what the states will do. And there will be some affirmative teams that haven't really thought through this very well that will just mandate what the states can do. Federal legislation can't just tell state and local police, you will do this or you will do that. The Supreme Court can, in a way, if it rules that certain things violate the Constitution, but Congress can't just directly tell local police departments what they can do. That's in the province of the state governments. What they do, and what almost all federal legislation does do, is to create incentives. So if you want to continue to receive federal funding for law enforcement, then you need to meet this standard. That's the typical format that the federal government uses. But again, numerous affirmative teams are going to write their plan in such a way that totally ignores that problem and therefore make themselves subject to federalism disadvantages and other problems as well. All right, let's talk about some disadvantages. And that's certainly not an exhaustive list of topicality issues either, but just to get on to some disadvantages. So first is a movement's disadvantage. And this disadvantage could either be used in conjunction with a defund the police counterplan or an abolition counterplan, but more likely it's just an alternative to that, which really makes the same argument. And the argument would be momentum is building for this now. And that's a very real world argument. There's a lot of momentum that's building in the country for abolishing the police or defunding the police. And for people who haven't really been introduced to the nuances of this current argument, that may seem so radical that it's just out there and crazy. But you just need to look at the examples, the example in New Jersey, of where the police department was so corrupt that the decision was made to actually get rid of it and to start from ground up and say, how should we build a policing operation? And so as you get into this literature, you know, your students will probably think, first of all, oh, abolishing the police, that's just crazy. That's, you know, how could that possibly even happen? But as you get into the literature, you will find some real world examples where it's worked, and also read some real world explanations of what people are talking about. So just basically eliminating the current police model and building an alternative model from the ground up. And again, the negative argument is it just doesn't work to reform. The problems are too serious, and there's also quite a bit of evidence that reform co-opts abolition. That if you reform the police, then you diffuse the grassroots movement, and the grassroots movement for defunding the police offers the real answer. So consider this piece of evidence from Bill Keller at the Marshall Project, writing in 2019. Abolition has become a rallying cry for the progressive wing of the justice reform movement. Jeremy Travis told me, no new jails, no more money for police, abolish ICE, abolish prisons. Travis, who oversees criminal justice issues for the Arnold Ventures Philanthropy, has spent a career in the system, most recently as president of the John Jay College of Criminal Justice in New York. And he says there's a lot of energy behind this reframing of the reform agenda. So you need to position what's happening at the grassroots level as an alternative to reform. And this is actually kind of an up-to-date version of the old hollow hope disadvantage, where the argument there more specifically is if the Supreme Court rules something, it actually diffuses the necessary social movement, that the real change needs to happen in hearts and minds and among people. And that won't happen if they just feel like, oh, well, the problem's been solved, so let's turn on to something else. Right now, we are at a moment of a significant crisis in criminal justice. And so the movement people, the grassroots people would say, we need to take advantage of this time. So this disadvantage offers kind of a centerpiece for argument for a negative team that wants to go to the left of an affirmative case that wants to reform criminal justice, rather than to go to the right of it. Political left, I'm talking about. An elections disadvantage, this is going to be big, at least until November, and unless it becomes clear that it's actually going to be a landslide. But still, at present, there's a considerable amount of evidence saying it could go either way. Trump could yet reframe, fix, whatever. So any disadvantage argument basically has to have a uniqueness argument. In other words, at the existing time, the disadvantage won't happen. It needs to have a link argument, and then it needs to have an impact argument. So the uniqueness argument for the elections disadvantage, at least before the 2020 elections, is going to be that if things go as they are now, Trump will lose the 2020 election. But you need to have some brink evidence that it remains closer than people presume. It could go either way. And in particular, Trump could recover among independent voters. So he has his core block, but that's not enough to get him elected. He's going to have to reach into independent voters as he did in 2016. And he could do that instead of by doubling down, as he's doing right now, attacking criminal justice reform, attacking the Black Lives Matter movement. If he were perceived as embracing criminal justice reform, if like a significant criminal justice reform package were to be passed by Congress and signed by the president, that could diffuse that anger among independents and bring them back into, oh, well, let's save the economy and so on. And then the impact could go a number of different ways, but a common impact right now is just that it's going to cause a climate crisis, that we can't afford 4 more years of inaction on climate change or we'll have true disaster. But there are a number of other directions that the impact could go. Could go into foreign wars or with Iran, etc. And while we're still on the elections disadvantage, you know, as those of you who are experienced debate coaches, you know that an elections disadvantage never goes away. It won't go away after the 2020 election. Not that it can keep the same format. It will instead turn to, okay, well, what will be the Biden agenda then, or what, you know, whatever. And so doing this would, you know, turn the agenda into a negative way. And so the elections disadvantage will change, but it won't go away. Federalism disadvantage. So the traditional form of the federalism disadvantage on earlier topics finds its impact abroad, where we talk about the example of US federalism prevents war and so on in societies where they have, if they don't adopt federalist solutions, allowing sovereignty to some subregions within the country, it's just going to be a formula for unending civil war. There probably will be some of that impact. Probably people will still be reading old evidence. I haven't seen a lot of brand new evidence on that kind of impact, but those are the big picture impacts. So the uniqueness argument is that at present, federalism is alive and well, but having federal mandates in the area of criminal justice reform upset the balance of federalism because policing is uniquely a state and local responsibility, unless we're talking about the FBI or ICE. Most of the criminal justice reform arguments are talking about local police. So it becomes a matter of what states and localities should do. So this could be combined with a state's counterplan or stand on its own. Court backlash. So this is one of those Supreme Court arguments. Someone asked in the affirmative session, what kinds of arguments will it generate if the affirmative plan has the Supreme Court do something? We have an interesting tension between President Trump and the Supreme Court. And he has appointed members of the court, and he assumes that that's going to cause decisions to go his way. He's won some, he's lost some. But the argument here would be, so far at least, he hasn't directly stood up against Supreme Court rulings in the sense of saying, I'm not doing that. You know, I'm the commander in chief, I'm in charge of law enforcement, and I'm not doing that. But there are those who worry that Trump would defy the Supreme Court if it invalidates things that he deems essential to his base. Like, for example, substantial criminal justice reform. And if the president were, Trump or any president, were to defy a Supreme Court ruling, there's certainly a long-standing body of evidence that says that would destroy the rule of law with disastrous consequences. And here, too, there's the great example of international implications of this. If the United States sets the example that we're no longer going to follow the rule of law. Well, this is a standby argument on nearly every topic. Hegemony bad. Could either be hegemony good or hegemony bad, depending on the direction the affirmative case goes. But there will be affirmative cases on this topic. We have one in the Baylor briefs, as a matter of fact, which makes case side claims that right now the United States is losing its soft power and its leadership around the world because of our bad human rights policies as it relates to policing. And the case evidence will claim that the United States restores its soft power on human rights and will reestablish US global leadership. The temptation will be for a negative team to just simply grant both of those arguments. Grant the first one, which grants the uniqueness of the disadvantage. Grant the second one, which grants the link to the disadvantage. And now the whole debate just comes down to whether US global leadership is good or bad. And as you see on the screen, Noam Chomsky is obviously the big, at MIT, the big arguer for United States hegemony leads to unending wars. But there are many others as well. This piece of evidence comes from Stanley Wortham, who was at the Saltzman Institute of War and Peace at Columbia University, writing in the New York Times. In the Middle East, endless war began when the United States first stationed troops permanently in the region after winning the Persian Gulf War. A circular logic took hold. The United States created its own dependence on allies that hosted and assisted American forces. It provoked states, terrorists, and militias that opposed its presence. Among the results, the United States has bombed Iraq almost every year since 1991 and spent an estimated $6 trillion on post-9/11 wars. So it bankrupts the United States. It undermines the rule of law. It creates unending chaos and war around the world. Those are the arguments against United States hegemony. Well, one that you've seen if you've been watching the news today, arguments that saw local police chief making this argument exactly on the news this morning, that when you intimidate the police, when, for example, you pass things like getting rid of qualified immunity, letting police know that they can be sued for anything that they do, that their job no longer protects them as an employee of the government from suit, then they simply won't go into neighborhoods where there's high crime. And so the 100+ murders, including many of small children that, well, some of small children that happened this last weekend, some attribute that to police are learning the lesson that they cannot go into disadvantaged neighborhoods to disrupt crime because they will be perceived as being overly aggressive. And so resurgence of crime will happen, and resurgence of crime undermines the US economy, has a devastating impact on minority groups themselves. So that's a possible argument, and that's, again, an argument that kind of goes to the right of the affirmative case. So think carefully when you choose that decision, but there's certainly evidence for that. Patrick Sharkey, for example, a professor of sociology at NYU, writes in the 2018 book, Uneasy Peace, The Great Crime Decline, the Renewal of City Life and the Next War on Violence, says the decline in violence has led to stunning benefits for the most disadvantaged segments of American society, most notably young African-American males. Every segment of the population has experienced a decline in violent victimization, but the most disadvantaged groups of Americans have benefited the most. The drop in the homicide rate is one of the most important public health breakthroughs of the past several decades, saving tens of thousands of Black lives and reducing the racial gap in life expectancy. All right, so let's talk about case responses. A little bit of philosophy, first of all, and this is going to be a hard place where you're going to talk to your debaters about designing a strategy. So against a criminal justice reform case, and the prototypical example being the George Floyd Justice in Policing Act, you can certainly find evidence. Heather McDonald, for example, author of the 2015 book, War on Cops, a lot of evidence there saying, well, you know, the police are really just doing their job and the statistics are misleading and so on. You can go there if you want. And it's really a tough decision for a debate coach, because normally what you want to say is encourage your debaters to take on the positions that they believe are true. And you will have some debaters who believe that the truth is that all of this is a hoax. And, you know, good luck in dealing with all of that. What I do want to share with you is my dear hope that as your debaters become informed about what's happening in the US criminal justice system, they will understand the need for changes. And I know that that won't happen for all of them, but it also just does need to be said that there's a pretty strong consensus in the debate community. You'll find very few college judges, for example, who won't bring into the debate round a fairly healthy presumption that something is wrong with the criminal justice system. And so if you're just going to take your stand on, no, there's nothing wrong with it, it's fine, it should be left like it is, you're kind of working against a pretty strong presumption. And you can say to yourself, well, you know, that's just that crazy community of college kids. But right now, if you look at national polls, as I mentioned in the affirmative session, there are a lot of national polls that say it's about 80-20 right now. 80% of the American public recognizing that there are problems, that there is a reason to be sympathetic with the Black Lives Matter movement, regardless of what you think about the particular organization. And so you're working against that, and just going to have to leave it up to you all as debate coaches how you manage that with your particular debaters. But it's a very tough road to go if you expect to win a lot of debates, because it isn't just the high school or the college debate judges that are going to carry that presumption. That's a growing presumption in the country, and I would say it's likely to be especially strong among also high school coaches and teachers who make up the majority of the rest of the judging pool. So take that into consideration. And so what do you do with a case like this? A case that's urging reform in criminal justice along the lines of that sort of national consensus right now, obviously passed overwhelmingly in the House, not with Republican support, but here are some things that you can do with it. You can run to the left of this policy and argue, and you don't even have to be that radical to do it in this version. You can argue that the only real solution to the problems that are being pointed out are not orders from headquarters from the federal government, but instead come from grassroots change in the community. And those grassroots changes are happening. State after state is adopting changes. Local communities are adopting changes. Changes are happening at the level where they need to happen, and public attitudes are changing. So consider this piece of evidence, for example, from Lee and Lodi, the fellows at the Marshall Project. This evidence comes from June 18th, 2020. 18 days after George Floyd was killed by a Minneapolis police officer, the Minnesota State Legislature introduced 48 bills in a special session on law enforcement. On the same day, Iowa Governor Kim Reynolds signed a law restricting police chokeholds. New York City Governor Andrew Cuomo signed a series of police reforms into law, including repealing an obscure law, Section 50A, that shielded police disciplinary records from public scrutiny. So, you know, you can just Google it up. There's a lot of evidence about grassroots change and grassroots movements. And you can also put together quite a bit of evidence saying that's the only real solution to these problems, is to have change at the grassroots. Here's another thing, and this is a mainstay argument that negative teams can make while we still have the Trump administration in power. And it almost tempts me to think about old college arguments that we used to make about a time frame counterplan, to just say, enacting criminal justice reform that would have to be enforced by the U.S. Justice Department in the Bob Barr U.S. Justice Department, that's worthless. The U.S. Justice Department can't be trusted to enforce civil rights protections. And there's a lot of evidence that you'll find on that, where we have laws now that they're simply refusing to enforce because of the political predisposition of Donald Trump and Bob Barr, the US Attorney General. So the negative position, the story that you're going to tell is grassroots is where it's at, and grassroots changes are happening. The federal government is a failed mission. Whatever, even if Congress were to pass it and the president were to sign it, enforcement in the current Justice Department would be a mockery. So states and localities are best to address police reform. And that enables a number of disadvantages: an elections disadvantage, a movements disadvantage, the crime resurgence disadvantage has a little bit of tension in it, certainly, but a federalism disadvantage, a hegemony disadvantage if you wanted to do that. So federal action, not a good idea. That's a story that you're going to tell on a lot of these changes. Whenever the states can make the change, especially if you have debaters who can run a state's counterplan, then it's going to be better solved at that level than to put it in the hands of the US Justice Department. All right, let's talk about forensic science. So independent crime labs. So there are a number of case side arguments that you can make, certainly, arguing that we have professional accreditation for crime labs, that the kinds of problems that have been pointed out by Sandra Thompson and others in the way crime labs are doing their work has actually exposed the problem and the changes happening where it needs to happen in state agencies. So states are increasing their oversight over crime labs, and that approach is superior to federal control. Furthermore, accrediting agencies have gotten more serious about paying attention to bias in crime labs. This piece of evidence from Radley Balco, writing in the Washington Post, June 7, 2018. According to the Bureau of Justice Statistics, 88% of the 409 publicly funded forensic crime labs in the United States are accredited. Unaccredited labs are typically very small, less than 10 people. They offer services in a limited number of disciplines. In addition to forensic laboratories, laboratories performing other types of tests are accredited according to the same international standards. So let accrediting agencies, let state agencies take care of this, and you'll find quite a bit of evidence talking about states are acting to try to deal with problems that have been exposed by the National Academy of Sciences 2009 report and by other critiques of crime labs, that there are adjustments that are being made at the state and local level, and that that's the better place for action. Reforming DNA collection and testing. Well, so here, the Innocence Project has been very involved in promoting DNA testing, in working on perfecting DNA testing. The Innocence Project, Barry Scheck and Peter Neufeld, founders of the Innocence Project, and Neufeld, one of its founders, writes in a post, DNA's revolutionary role in freeing the innocent. The idea was simple. If DNA technology could prove people guilty of crimes, it could also prove that people who had been wrongfully convicted were innocent. Research shows that 99.9% of human DNA is identical, but that 0.1% can be used in forensic labs to differentiate one individual from another. So basically, you're just relying on evidence that DNA testing is improving, it's getting better, and the problems that have been exposed in the past are being addressed, that the court itself provides scrutiny for these kinds of things. There are some affirmative cases that are going to focus especially on the collection and storage of familial DNA for searching. The CODIS database already puts restrictions on the searches that states can conduct in the CODIS system for familial DNA. So those are some case side arguments that you can make against a DNA collection and testing case. Testing of rape kits. Well, first of all, there is the inherency argument here that the Debbie Smith Reauthorization Act just passed early 2020, increases funding for the testing of rape kits. So this article, for example, in Newsweek by Benjamin Fearnow, January 1st, 2020, President Donald Trump signed legislation Monday that allocates funding to help states clear the backlog of more than 100,000 rape kits across the country, ending several years of nationwide initiatives to get federal support. You can also argue that rapid DNA is revolutionizing the testing of rape kits. So this article, for example, in the University of Richmond Law Review by Emma Greger, May 2018, while rapid DNA technology has the potential to revolutionize every aspect of the criminal justice system, from arrest to the post-conviction appeals process, there has been particular excitement centered around its potential to reduce the rape kit backlog. So rapid DNA, this is like a machine that can just sit on the counter. You submit a DNA test and you get results in like 15 minutes. It's the kind of thing where you can still have a suspect in custody and conduct a DNA test while they're there. And while courts are not yet happy about introducing evidence from rapid DNA, it's the kind of thing that can sort out the problems. So if you have people if you submit a sample to a rapid DNA test and it tests positive, then in order to go to court to satisfy the court, you can have a more complete test. But quite a bit of evidence that rapid DNA technology offers the way to clear the rape kit backlog. So facial recognition systems. This is one of those technologies that it is possible to defend on the case side if you want to. So think about what we would do without facial recognition systems in airport security. Think about its potential to deal with human trafficking, for finding missing persons. There's a lot of evidence talking about how this technology is repairing many significant problems in our society. So rather than to ban it, focus on the privacy protections, the privacy laws, et cetera. You can also argue that the accuracy of facial recognition systems is improving at a rapid rate. There's one affirmative example that makes the rounds in attacks on facial recognition systems, which applied the technology to current members of Congress, I think in the last session. And it identified quite a number of members of Congress, including a number of members of the Black Caucus, as matching a criminal profile. There are critiques of that study that say the particular facial recognition software system that they used allowed you to set it on whatever setting that you wanted to, whatever percent accuracy, and that it was set on 80% accurate with that particular thing. And the critique of it say, when you set it to 95%, it would have made no mistakes. So anyway, there are some case side arguments that you can make on facial recognition systems. Banning predictive policing techniques. As you may have discovered if you prepared for debating the Lincoln Douglas topic earlier this year, it's a fairly two-sided topic in the sense that predictive policing software, again, like facial recognition, has been used and can be used productively in a number of areas, like finding child predators, restricting human trafficking. It's especially good for policing online hate crime kinds of issues and so on, in the way that it follows leads and et cetera. And but the most interesting argument to me is one that's actually made by the big advocate of restricting predictive policing, Andrew Ferguson. And both in his main book, Big Data Policing, and in several law review articles, including this one, Andrew Ferguson, professor of law at Clark School of Law, this article in the Vanderbilt Law Review, March 2019, he talks about what he calls not just the black surveillance, which is the problem that he highlights, but he also highlights that these same systems provide blue surveillance, meaning surveillance of police officers. So here's what he writes, for example, in this Vanderbilt Law Review article. New data surveillance systems built by the police can also be used to monitor systematic and recurring police practices. In every Big Brother-esque example discussed above, by him he means, technology also captures police-citizen interactions in new and revealing ways that can help expose existing police abuses. The great irony of the modern surveillance state is that law enforcement accidentally designed a system that can monitor police behavior better than its citizens. So there's an interesting argument made by several, including by one of the main authors use to criticize predictive policing techniques, saying that this may also, however, offer the solution to police abuses in that it stores and records and it analyzes police citizen behavior and can therefore, by a police department that's determined to root out poor police practices, or cities that are, or states that are, it provides the technology to do that. Reforming jurisdiction in Indian country. Well, this case is positioned in such a way, we're used to it on most topics, that if you're talking about an Indian country case, a state's counterplan you would normally think won't work. Actually, in this case, it will work. And what you have to look for is evidence on cross-deputization agreements. So the argument that you want to make when you're negative against this case, against this limited jurisdiction of tribal authorities, is that many states and localities have promoted the use of cross-deputization agreements, recognizing that enforcement needs to happen on and off the reservation for both sides, for both state law enforcement and for tribal authorities. And so what you really need is to increase cooperation between local police departments, state police departments, and tribal authorities. And that's what cross-deputization agreements do. So Jessica Allison, for example, writing in the University of Colorado Law Review, Winter 2019, says this: cross-deputization agreements are a common remedial measure for this jurisdictional web. These agreements allow different law enforcement agencies or government entities, 150, well, that's a footnote, never mind, to exercise jurisdiction where they otherwise would not be able. For example, an agreement might allow state officers to respond to a crime in Indian country between two Indians. This measure is particularly beneficial in instances in which a tribe lacks sufficient law enforcement officers, but the state or surrounding county does not. In the case of sexual violence, cross-deputization agreements can ensure there is a prompt and efficient law enforcement response without the preliminary jurisdictional questions. So you could have a counterplan which just builds on what's already a very widely used solution to this, and just have cross-deputization agreements between, in those states where there are Indian reservations, promote cross-deputization agreements. And together with that, you can use the overarching argument that reliance on the federal government to fix this problem and to provide enforcement is a losing proposition. Reforming military-style policing. So the case side argument here starts with an argument that most of this equipment is not big military stuff. It's instead little stuff. So Michael Webster, for example, writing in the University of Illinois Law Review 2016, in fact, most of the $5.1 billion that has been given out to police forces throughout the country has actually been non-tactical gear, such as sleeping bags and filing cabinets. For example, the Los Angeles Schools Police Department has received over $700,000 worth of non-weapon supplies through the 1033 program. Moreover, it's important to note that even though some of the non-routine gear, such as bulletproof vests, can help, well, I read that wrong. Moreover, it's important to note that even some of the non-routine gear, such as bulletproof vests, can help save lives and keep agents safe as they protect the community. So if, for example, the affirmative plan bans all 1033 program, you'll find evidence that more than 95% of it is non-weapons. It's just surplus equipment that the Defense Department has, like filing cabinets, like copy machines, etc. But also, you'll find evidence that big pieces of military equipment, like MRAPs, mine-resistant ambush protected vehicles, come in handy when there's a natural disaster. So if you just Google it up, you can find, for example, that in Hurricane Harvey, local police departments that had MRAPs were able to go into areas that were flooded and ferry people out. using heavy military vehicles that they wouldn't have been able to save otherwise. So there are times that you need the big military equipment. And again, all of this can be put together with a negative, either a state's counterplan or a negative argument that the way to fix this is just to put state and local controls on the use, receiving big military equipment or the use of that equipment. So don't allow it to be used, for example, to put down demonstrations and so on. Reforming the policing of immigrants. There's some interesting negative arguments here, case side, and it might seem like this is a losing proposition for the negative. Keep in mind your topicality positions on this. So a lot of affirmative plans that deal with immigration are going to be ranging into non-topical ground. They're not going to be dealing with sentencing. They're not going to be dealing with policing, really. They're going to be changing the law that police are then enforcing. And so you've got a lot of topicality ground. But in addition to that, in some ways, the easiest part of this to defeat is the most topical portion, the 287G agreements. And you can point out that those agreements, and by the way, if you look at my answers in the fourth issue of the policy debate, what are we calling it now? Not the Forensic Quarterly, but
Quarterly, Policy Debate Quarterly.
Policy Debate Quarterly, thank you.
We've changed the title, there you go.
We've changed the title. So the affirmative argument in number 3 that was argued by the folks at Wichita State focused on the immigration-related issues with 287G agreements. I answered those arguments in the fourth Forensic Quarterly. And it's interesting to note that those have not increased significantly under Trump. They've increased by a little bit, but in fact, many of the localities that had agreements have abandoned them, and the ones that exist are primarily in rural areas where there aren't a lot of immigrants anyway. And here's the really, really interesting thing, and I make a big deal of this in that fourth issue of the Policy Debate Quarterly. There are 2 authors, and they've written a number of law review articles, but Hyun Pham and Pham Van. The first is professor of law at Texas A&M. The second is professor of economics at Baylor. This particular article is in the New York University Law Review, April 2019. And they make the argument that, ironically, the Trump administration push to try to hurt sanctuary cities has backfired in a major way. That in fact, the number of sanctuary jurisdictions has increased, and that pretty dramatically, despite Trump administration efforts, which have mostly been frustrated by the courts. Even the Trump appointed court people have protected sanctuary cities from the ire of the Trump administration. But consider this example of evidence that they offer. And this article is just amazing. And I think it's generally available on the internet. It exists in the underlying notes to the PowerPoint that you can download. They say, first, the most visible manifestation of the Trump effect was the sharp growth of sub-federal immigration regulation in 2017. Now that sounds bad, but this regulation was overwhelmingly pro-immigrant in nature. Much of this growth occurred at the city and county level. In 2017, cities and counties enacted more immigration regulation in this single year than was ever enacted in the previous 12 added together. These laws are almost uniformly immigrant protective, focusing on policing laws that limit the authority of local police to cooperate with federal immigration enforcement, or laws protecting access to local services, regardless of immigration status. So, you know, there's a lot of case side argument that you can make that despite the best efforts of the Trump administration, the best solution to the protection of immigrants, and which by the way was also true in the Obama administration, because the Obama administration deported a lot of immigrants. So you can argue the best protection for immigrants are sanctuary laws, sanctuary jurisdictions, Most of America's major cities are sanctuary jurisdictions. There are hundreds of them. Some whole states are sanctuary jurisdictions. So that's a pretty interesting case side argument. Also, this case area is very subject to topicality arguments and a counterplan. So, for example, if in fact it's not topical for the affirmative to ban the deportation of immigrants, you know, why not just argue, you know, okay, we're not going to give the Trump administration the credit to deal with the elections disadvantage and other kinds of things that the affirmative is going to do, but you could just have a counterplan that would ban deportation, for example, using the evidence that that's civil and not criminal law. So the immigration case is challenging on the negative, but there's more evidence than you might imagine. Reforming the policing of juveniles. So this is the SRO case. So again, here on the case side, there are more arguments than you might imagine. First of all, the affirmative argument is based upon what you can claim is, and what you can argue is an empirically false claim that the school to prison pipeline is increasing. In fact, there's pretty good evidence that it's decreasing. So consider this piece of evidence from this web post, MST Services, Youth Crimes Drop, but Progress is Still Needed. They say from the peak offense rate of the 1990s to today, juvenile crime arrests have dropped across the board in leaps and bounds. Robbery and aggravated assault rates have dropped by 70%. Since the 90s, assaults are down by 49%. Murder rates have fallen a staggering 82%. Juvenile confinement in prisons and jails dropped by 83%, or 53%, I'm sorry. Also, there are some inherency arguments you can make if you want to. Janet Decker, for example, writing in the Utah Law Review of 2017, says this: local law enforcement agencies typically were awarded a 3-year grant to fund an SRO program. At the end of 3 years, it was anticipated that the local law enforcement agency would be able to continue to fund the position using a variety of sources other than federal grant money. Between 2005 and 2013, federal grant money for SRO programs became unavailable. In 2005, federal grants through the Cops in Schools programs ended. And in 2009, funding through the Safe and Drug-Free Schools and Communities Act ended. The lack of available grant money led to a slight decline in the reported number of SRO positions after 2005. While the number of SROs nationwide had climbed to approximately 19,900 in 2003, by 2007, the last year for which there is available data, the number of positions had declined to approximately 19,000 full-time SROs. So you can actually argue that if what the plan does is to stop federal funding for SROs, you know, according to that piece of evidence, that's already happened. It's up to the states and localities now, which would mean this is also very subject to a state counterplan. Also, you can argue that zero tolerance, which is one of the big arguments that these affirmative cases are likely to make, is now on the decline. It's a policy that had a big, you know, thing after some of the school shootings that were very highly publicized, but is very much on the wane now. So, for example, this article by Chris Curran, professor of education at the University of Florida, February 14, 2019, I found that as of 2013, only 7 states and 12% of school districts had discipline policies that were based on zero tolerance. While almost all states and about 2/3 of districts had a policy that required expulsion for certain infractions, these state laws and district policies overwhelmingly applied to serious infractions like bringing a gun to school. So, you know, more evidence for the decline in, you know, school to prison pipeline. This is Matthew Steinberg, professor of education, University of Pennsylvania. What do we know about school discipline reform? This is an article from winter 2017. A recent National Center for Education Statistics report documented downward trends in suspensions, student victimizations, reports of bullying. Since 2006, out-of-school suspensions have declined, with more recent declines in expulsions. So while the affirmative team can read anecdotal things about an SRO locking somebody up for a minor offense, it can't really be argued that the presence of SROs in schools is causing a big increase in the school to prison pipeline, because that pipeline is drying up, it's going down. A related affirmative case dealing with juveniles, probably more in the sentencing area, is going to talk about not confining juveniles with adults. But when you're debating that case, you need to be aware of the passage in 2018 of the Juvenile Justice Reform Act that was reauthorizing the juvenile justice, the General Juvenile Justice Act. Those amendments became effective in fiscal year 2020, so starting October 1st, 2019, and it essentially bans the presence in adult prisons and jails of juveniles. So that problem too has been addressed. All right, let's talk about civil asset forfeiture. So, you know, I'm showing you on the screen this case, Timms v. Indiana. This is one of those egregious cases. Tyson Timms, TIMBS, was arrested for a minor drug offense, fined $1,200, but the police department in Indiana also kept for their own use a Land Rover, which was an SUV that he had just purchased with insurance money from his father's death. It cost like $42,000. He went to court claiming that the seizure of his property constituted an excessive fine prohibited by the language of the 8th Amendment. So the Solicitor General for the state of Indiana claimed that the police had a right under state law to seize the vehicle under civil asset forfeiture, and that in any case, the 8th Amendment preclusion on excessive fines had never been applied to the states. So this is the case that I was referring to on the affirmative, where actually the Solicitor General from the state of Illinois claimed that in answer to a question from the Supreme Court Justice, so if a person goes 5 miles over the speed limit, can you seize their car? And he said yes. Well, the Supreme Court was not impressed by that argument. Timms v. Indiana was a 2019 unanimous decision written by Justice Ginsburg that ruled that the 8th Amendment statement that, you know, ban on excessive fines applies to the states as well as to the federal government. So if you're negative, you can argue. I know it's hard to win with an inherency argument, but this is a fairly recent Supreme Court decision, and the affirmative team needs to have some answer to why that doesn't solve the problem of abuse with civil asset forfeiture. So Alan Pike, for example, a staff member at Think Progress, writes in Supreme Court's new ruling on civil asset forfeiture is pretty huge. This is a February 20th, 2019 article. States cannot ignore the Constitution when imposing fines or confiscating people's property in civil or criminal cases. The Supreme Court unanimously ruled Wednesday. The decision in Timms v. Indiana means changes on the wind for the widespread and chronically abused law enforcement tactic of civil asset forfeiture. All right. Forming Muslim surveillance. A little bit of background is necessary here. I mentioned when we talked about this case on the affirmative that CVE, countering violent extremism, dated from the Obama administration, not from the Trump administration. And there was a reason that President Obama adopted CVE. Consider this piece of evidence from Cora True Frost, professor of law at Syracuse University School of Law, College of Law, writing the Michigan State Law Review 2017. From 2009 to 2013, UN counterterrorism efforts continued with an increasing focus on prevention. In 2014, the UN Security Council made CVE a legal obligation for states. Daunted by the continued scattered terrorist attacks in Europe and in the United States, and perhaps encouraged by broad state compliance with its 1373 regime, the UN Security Council directed states to address the conditions conducive to terrorism. Security Council Resolution 2178 invokes Chapter 7 and orders states to embark on a societal approach to countering violent extremism. In the same resolution, the Security Council also deemed extremism to be among these conditions conducive to terrorism. So the Obama administration, in response to that Security Council resolution, adopted CVE policies. And those policies were really designed, especially the way the Obama administration adopted them, to be like a community policing, you know, let's establish friendships in Muslim communities. And so this article in the Hastings Law Journal, February 2018, by Badoun, professor of law, University of Detroit Mercy School of Law. Community engagement is central to CVE. Law enforcement relies heavily on informants within the community to gather information on a radicalization project, and when he or she is graduating toward action, turning that individual. DHS and local law enforcement seek to partner with civil organizations, religious centers and leaders, private businesses, high-profile community members, students, and more. Therefore, individuals immersed and respected in the community are the best conduit for communicating with local law enforcement. By building these community relationships and inroads within spaces where Muslims worship, congregate, and frequent, CVE relies upon its community interlocutors and informants to monitor and gather information about subjects of interest, and in many instances identify and tip law enforcement about new subjects purported to be prone to radicalization. CVE policing followed in the footsteps of the theory and focused almost exclusively on Muslims. Here's the really interesting thing to me. In the articles that you'll find about how CVE changed from the Obama administration to the Trump administration, there were many dire predictions about how this program would be run under the Trump administration. But surprisingly, a lot of articles say the Trump administration has not turned it into a big oppressive thing. So for example, here is Seamus Hughes, Deputy Director of the Program on Extremism at George Washington University, writing in a post, Trump's domestic countering violent extremism policies look a lot like Obama's. He writes, the terrorism prevention bureaucracy has been quietly and slowly grinding along for 2 administrations. If you liked domestic CVE policies during the Obama administration, you should like them under the Trump administration. The article goes on to say, surprisingly to many people, the Trump administration has left in place even the same director of the CVE program that President Obama had placed in charge of that program. So anyway, there are some case side arguments that you can make on even on Muslim surveillance. Policing of violence against women. So this, if you remember, is the affirmative case that I suggested, where you would have the affirmative go the other way on the resolution and crack down more on policing, or give police more money to do, require that they do more things. So if you're negative, what do you do against this case? By the way, in the broader number of cases, like the cases that are going to increase policing, there's also a topicality argument you can make about the interpretation of the word reform, which is to correct past abuses. And you can make the argument that that limits the affirmative to a one side of the resolution rather than a bidirectional resolution. But this case dealing with violence against women, let's talk about some of the particulars of the case. So you can argue on the negative that this is an argument that you've heard in the news a lot lately. Asking police to do something that they were never equipped to do and should not be asked to do is a formula for disaster. You're asking the police to do the work of community service agencies. So mandatory arrest policies for people that violate orders. You're trying to turn police into social workers, expecting them to solve all social ills, which is a formula for disaster. You're bringing the police into closer and closer contact with fragile communities. So someone who really doubles down on that argument is Lee Goodmark, professor of law at the University of Maryland. She's the author of a 2018 book entitled Decriminalizing Domestic Violence. Pretty interesting title. the subtitle, A Balanced Approach to Intimate Partner Violence. She argues that criminalization is really the wrong way to go when we're talking about dealing with domestic violence. Here's a part of what she says in the book. Criminalization has increased state control over women through the intervention of the child abuse and neglect system. Increased police involvement in families experiencing intimate partner violence leaves mothers who are subjected to abuse at greater risk of being reported to Child Protective Services agencies, failing to protect their children, and from exposure to that violence. Some police departments require officers to make a report to Child Protective Services whenever a child is present at the scene of an incident of intimate partner violence, coupled with state laws and policies that hold mothers accountable for their inability to prevent their partners from being violent in the presence of their children. The increased involvement of the criminal justice system means greater scrutiny of women's parenting and an increased likelihood that mothers will lose their children. Goodmark also talks about double arrests that happen, like when police show up with domestic violence incidents, both sides are often claiming that the other one was abusive. And so what the police will often do is arrest both parties and let the court sort it out, but that often results in a criminal arrest record, which gets your children taken away, and sometimes has led to local or state legislation with, actually claiming the mother abducted the children. So here's another author writing the William and Mary Journal of Law, Race, Gender, and Law, fall 2018. This is Michelle Jacobs, professor of law at the University of Florida. During the period leading up to the enactment of VAWA, the Violence Against Women Act, Black women and Latinas warned that mandatory arrest policies might actually increase the rate of violence in their communities. The mainstream anti-violence advocates devalued the validity of this concern, usually cloaked in eerily paternalistic language. By 2002, it was clear that data was developing that suggested in some cases, advocates for Black women and Latinas were right. Violence would increase as a result of mandatory arrest. So with this case, it's kind of like, be careful what you ask for. And again, over the last few weeks, all of us have seen a lot of evidence talking about the bad things that happen when you ask police to do more than what they should do, when you ask police to solve all of our social problems. All right, let's talk about sentencing cases. So abolishing the death penalty, you have to make a decision on the negative, what you're going to do with this particular case, whether you want to use a counterplan strategy, whether what you want to do, but you can defend the death penalty case side straight up if you want to. There's certainly evidence that the death penalty does serve as a deterrent. The weight of the evidence is probably on the affirmative on that issue. There's an interesting law review article that argues that the death penalty serves as an incapacitator, using the argument that someone who is in prison with life without parole now has no reason not to kill somebody because nothing worse can happen to them. So they become a danger to everyone in prison, prison guards, other prison inmates, and this author of that law review uses a number of examples where that has happened. But the other interesting strategy is there are a number of arguments that life without parole is in some ways worse than the death penalty. How could that possibly be the case? Well, the argument starts with the idea that life without parole is the natural alternative to the death penalty. If you abolish the death penalty, what you're going to have in society is increased use, obviously, of life without parole. The problem with life without parole is you don't get anywhere near the scrutiny at trial of what happened, what the evidence is, has DNA been tested properly, all of that kind of thing. If it's a death penalty case, you have multiple appeals. You have many public services, legal services available to people to take them through that whole appeal process, none of which is available if you're just going to convict somebody of life without parole. And as numerous authors argue, life without parole is a death sentence. You're going to die in prison. And it's going to be a brutalized life. by the way that you're going to spend. Not that different from the experience of someone who is sentenced to the death penalty, because they're also going to spend most of their life in prison because of the length of appeals and all of that kind of thing. So the alternative, life without parole, is actually only a small improvement, and from some perspectives, you know, maybe not an improvement at all from the death penalty in terms of human rights. All right, let's talk about eliminating imprisonment for drug users. So there's a lot of evidence indicating that we are wrong in our assessment about how many people are incarcerated as a result of drug offenses. This is especially true if the affirmative case is talking about US prisons and jails in general. As we talked about in the affirmative, if an affirmative team is smart, they'll focus primarily on the federal system, where the number of persons incarcerated for drug offenses are higher percentage-wise than for state and local, where it's only about 16%. So Michael O'Hear, for example, professor of law at Marquette, writing in The Failed Promise of Sentencing Reform 2017, says this: calls to end mass incarceration by emptying the prisons of nonviolent offenders typically rest on mistaken assumptions about the importance of the war on drugs in driving the imprisonment boom. Many Americans are now strongly predisposed to view the war on drugs in negative terms, and thus too quick to assign to it the primary blame for mass incarceration. There's an ironic echo here. In the mid and late 20th century, many Americans were strongly predisposed to view drug distribution in negative terms, and thus too quick to assign it the primary blame for the nation's increasing crime rates. Drug enforcement is now scapegoated as drug distribution once was. In any event, whatever the other failings of the war on drugs, it did not fill the nation's prisons with plainly nonviolent drug offenders. Abandoning mandatory minimum sentences. So, first of all, we had, inherency-wise, we had the First Step Act, which did cut the number of sentences. But the negative can also argue that most sentences are short. The average sentence for a person even who is sent to prison is like 2 years that they actually end up serving. And only a small percentage of those who are in prison are there because of mandatory minimums, which means the impact on mass incarceration is small. Consider this evidence from Stephen Cook, president of the National Association of Assistant U.S. Attorneys, in the Federal Sentencing Reporter, October 2015. The central facts are simple and uncontested. The United States Sentencing Commission reports that only 14.5% of prisoners are serving sentences based on mandatory minimum penalties of any type, not just drug traffickers, including, among others, armed career criminals, serial bank robbers, and terrorists. So only 14.5% are serving mandatory minimum sentences, and that includes murderers, bank robbers, terrorists, etc. The final affirmative case we talked about was plea bargaining, limiting plea bargaining. So the argument that a negative team can make case side here is that the best protection against this, recognizing first of all that more than 90% of in the US, cases are settled by plea bargains. There's certainly plenty of evidence that our system would entirely break down if we eliminated plea bargaining. So as a case side argument, you can argue that the best defense against bad plea bargains are defense attorneys. But whenever you make that argument, typically the affirmative team is going to argue, oh, well, public defenders are overworked, they can't really do their job, etc. There's some interesting answers you can make to that. This one comes from Kelsey Henderson, professor of criminology at Portland State University, writing in the 2019 book, A System of Pleas, Social Sciences Contributions to the Real Legal System. Public defenders generated more favorable outcomes for their clients than did assigned counsel. Defendants of assigned counsel were more likely to be convicted of the most serious offense, received longer expected sentences, and suffered a longer wait period from arrest to adjudication than those of public defenders. Also, consider this quotation from a federal district court judge for the Eastern District of New York. This is Frederick Block, writing in Crimes and Punishments. He says, because indigent defendants get a lawyer free of charge, they often believe the old adage that you get what you pay for. Nothing could be further than the truth, from the truth. The federal defenders and CJA lawyers are among the best. Since they are always in court and try a great many cases, they are highly skilled and experienced. They can go toe-to-toe with the prosecutors and the best of the criminal defense bar. And because of the volume of work they handle, they are particularly knowledgeable about sentencing. I often comment that if I ever had to be sentenced, I would prefer to be represented by a federal defender or a CJA lawyer. So there's a pretty good body of evidence, surprisingly, saying public defenders are pretty competent. And that's the best defense against bad plea bargains. And also there's a lot of evidence that you can read saying plea bargaining by its very nature benefits both the prosecution and the defense. It saves the system money, it saves defendants money. It often means they go to prison for less time than they otherwise would have. Yes, there are instances where people plead guilty to something that they didn't do, and those are the egregious examples that the affirmative cases are going to point to, but most of those are, again, just particular instances rather than typical cases. So negative teams can have some pretty decent evidence to argue that public defenders offer, or defense attorneys in general, offer the best protection. So do we have some questions?
You do have some questions, Dr. Edwards. Let's go all the way back to the facial recognition. What was the study that you discussed during the facial recognition systems, Andrew Ferguson's book?
Oh, okay. Well, the book that I cited under facial recognition was actually from Kimberly Del Greco. I think there are two different questions here probably. And I'm not sure I actually read this piece of evidence that I had available. There's a two-part House hearing where there's a lot of good affirmative and negative evidence. It's available to anybody, obviously, online. The title of the hearing, and it's conducted in 2019. Title of the hearing, Facial Recognition Technology. It has a part 1 and part 2. So Kimberly Del Greco, Deputy Director of the Criminal Division of the FBI, says it's crucial that authorized members of law enforcement and national security communities have access to today's biometric technologies to investigate, identify, apprehend, and prosecute terrorists and criminals. The FBI's Next Generation Identification, or NGI system, which includes facial recognition, aids in our ability to solve crimes across the country. Facial recognition is an investigative tool that can greatly enhance law enforcement capabilities and protect public safety. But if you're asking about the Andrew Ferguson book, it was probably a citation that I used on the next case, which is banning predictive policing techniques. He's the big author in that area, both affirmative and negative, interestingly. And an article that he wrote in the Vanderbilt Law Review is the one that I quoted from March 2019, Vanderbilt Law Review, says new data surveillance systems built by the police can be used to monitor systematic and recurring police practices. In every Big Brother-esque example discussed, technology also captures police-citizen interactions in new and revealing ways that can help expose existing police abuses. The great irony of the modern surveillance state is that law enforcement accidentally designed a system that can monitor police better than its citizens. So Andrew Ferguson, both in his book, Big Data Policing, and in several law review articles that he's written, but this one where he focuses most on the negative kind of evidence is the Vanderbilt Law Review, March 2019. He talks about what he calls blue data. The data that these systems collect on police officers that can be used to root out abusive practices.
Another question is, could mandating mental health police officers in all departments fall within policing topicality?
Yeah, I think so. You know, if the harm argument argues that you have police officers who have problems, usually the problem that you read discussed is hidden biases. I mean, most departments have this training already, but you know, there are lots of critiques of the existing training methods. And more broadly, I suppose you could, you know, try to identify police burnout and police that have, you know, mental health problems. So if you require more training for police and your harm argument is that they're doing abusive things because they're acting out as a result of poor training and whatever, I mean, I don't know why that wouldn't be topical.